panel discussion is going to be more of a general overview of what these different attorneys are working on.
Anybody who's met with me over these last 18 months has known that my expectations of government are low, to say the least, and that these winds have been blowing for a very long time. When the police come across a small grow, 5 plants, 10 plants, usually a patient grow, and they don't know what to do, the first thing they do if there's kids in the house is call social services. And people have 3 times in the last week called my office because the children have been placed into custodial care because they were growing a few marijuana plants and they were completely legal to do so. But there is no legal precedent to deal with social services.
This House Bill 1284 is just crazy. I mean, you have to apply by August 1st on forms from the Department of Revenue that are not created, and you have to submit those forms to a local licensing authority that doesn't exist yet. And at the speed of government, I mean, they may not be ready until 2015.
Unfortunately, it's great that you have 10 great legal minds up here who all have slightly different ideas about how Amendment 20 is supposed to work. But at the end of the day, what we all think is irrelevant if law enforcement and people who will charge you see it differently. Just providing medical marijuana was the point of Amendment 20. And Judge Cross, who was the judge in that case, said, you can't ban a constitutional use. That Amendment 20 goes further than just saying patients and caregivers get to grow medicine. There has to be an outlet to provide that medicine. And unfortunately, what happened is some bigger dispensary interests here funded together, got themselves lobbyists to protect their interests, and the patients got screwed in the process. And the smaller caregiving operations that have more time and more focus on their patients are getting harmed in the process.
It's really going to come down to, you've heard this many times, well, what did the voters intend? Back in 2000, what did the voters intend? And when you have 1,000 people applying for the registry every day, that's the voters' intent. People are outraged. They're outraged over the law. And what they need to understand, and what everyone needs to understand, is the law is written, the letters is written, and emotional outrage is only going to get you so far. I definitely don't like what I call a rat clause in there that says if your registry card is suspended or revoked or expires, I believe, that your name is turned over to law enforcement. And they just totally screwed the pooch when it came to patients' rights. I see very, very, very little in this law that's patient-oriented. And law enforcement doesn't get it. They make tons of mistakes, and a lot of it's just based on education.
In regard to HB 1284, I feel like it's The Shining in Jack Nicholson where he says all work and no play. I've read this thing so many times, as we all have, frantic clients, and I think all of us should be frantic because it's an atrocity. Limiting the number of patients a caregiver can have, really, I can only read this one way, and really what it is limiting a patient's right to a caregiver. I don't see how you do that. There are very specialized uses of this medicine which specific caregivers can provide for certain patients. If you make vegan lollipops, and that's all you can use, to me the special exception that they provide is an unreasonable burden.
In the U.S. House of Representatives, House Judiciary Committee, there's H.R. 3939, which provides an affirmative defense to anyone in the medical marijuana state who's in compliance with the law and who uses medical marijuana. Jared Paulus of Boulder, Colorado is one of the sponsors. If you are in the grow business or in the dispensary business, you have to have a relationship, a very direct relationship, and you'll need your attorneys to help you draw up these contracts.
And I say we bring it, and we bring it hard, and we bring it all the way. We bring it in federal court because of the Fifth Amendment violations that are in SB 109. I say we bring it in state court for the many violations throughout both bills, and I say we bring it in local court. Part of the reason we ended up with such horrible legislation is because we got angry in the wrong way. Talked about the importance of making this patient-centered.
As long as we're able to set our egos aside and focus again on the patients and their access to medicine, I think that could be a very effective and useful resource.
The constitutional provision protecting the patients, and this bill interferes with the patient's access to medical marijuana, and that violates Amendment 20.
That you can't get rid of people who have cultivation convictions. Often, those are the best caregivers.
And it's a law enforcement legislative action, and there's no other way to interpret it.
And we don't really appreciate the threats that they're giving us. We have a 100% constitutional right for medical cannabis businesses and caregivers to operate right now the way it's going, and we don't see any reason to give up any of these rights. They have a saying that there's 3 ways to control your government: the ballot box, the jury box, and the cartridge box. And you better not take away the first 2, because you know what we're going to end up with. So, but back to the jury box. You need to, the doctrine is called jury nullification. How many people have heard of jury nullification before? Not very many people. That's why it's really important that you guys understand this. Jury nullification means that a jury has the power to go into the jury room and decide in that one case that this law is going to be nullified. We're going to let this person go because that's how we think justice would be served, by letting the person go.